All right, everybody. So this long video it was a lot of evidence that was submitted, and again, it was all submitted, all this evidence, December 26, 2018, twice. Once in a legal separation case, went to Rena Hughes again. My attorneys at the time, fully aware of what I filed, but allowed it all to be concealed and for litigation to continue against me. So after 2 years after they knew the fraud occurred, they let it continue, and then I get a divorce decree. And this was issued in August of 2020. So we went to trial in February, but there was no decree till August. The decree, longer than the marriage. So let me tell you what she wrote. This was a short-term marriage. The parties were married on November 25th, 2017 in Las Vegas, Nevada. The parties do not have any minor children, and Lindsay is not now pregnant. Lindsay filed her complaint for divorce in June 26th of 2018, and Bobby filed an answer in July 23rd. The parties came before the court on October 19th for their first case management conference and a hearing on the plaintiff's motion for orders for temporary spousal support, exclusive possession, and the court entered temporary orders, including granting Lindsay exclusive possession of the home, ordering Lindsay to pay the mortgage of the home, ordering Bobby to provide Lindsay with the name of the mortgage company, ordering Bobby to pay all utilities in his name, whereupon payment to Bobby could be present, Lindsay with a copy of the bills, and Lindsay would be required to reimburse him. Ordering Lindsay to pay all the past due utility bills, and an evidentiary hearing scheduled for March 26th. The order was was entered on December 18th, 2018. On December 2018, Lindsay filed a complaint for separate maintenance and separate action, case number D18581-756-S. Feel free to look it up. On January 10th, 2019, Bobby filed a motion to dismiss or consolidate. A hearing for the motion was held on February 13th, 2019, and at the hearing, the parties stipulated to grant Bobby's request to dismiss Lindsay's complaint for separate maintenance. The court denied Bobby's request for attorney fees and ordered the trial in the above case to remain on schedule. The March 26th, the parties stipulated to continue trial to a later time. The court then assigned amended case management order setting trial for August 2019. On June 11th, the parties again stipulated to extend discovery deadlines in the trial date. A second amended case amendment order was issued, setting trial for February. So she says they kept changing it. At no point did they ever talk to me about changing it. They kept telling me they had to. On January 8th, 2020, So she says there was a hearing held that gave me exclusive possession, and there was. So you see here is the order from the hearing. But do you notice here who's his attorney? Garrett Chase, Linda Na's attorney. So yes, you guys had the very same attorney. Yes, you did. And Linda Na came to court and said she didn't. So she slandered herself on the stand. So counsel for plaintiff was ordered to prepare the finding facts and conclusions of the law, but withdrew from the case because I found them committing malpractice. Counsel for the defendant prepared the proposed finding facts of conclusion from the court's journal entry. The court substantially modified and proposed it submitted by the defendant. Lies. The majority of the issues in dispute for trial stemmed from the purchase of the marital home. Shortly after the marriage, they purchased a residence. Lindsay did not have a good credit rating, as she had not held a paying job in some time, but did have cash on hand from her foundation. Bobby had good credit, but had some debt and little cash on hand. So we saw that's all a lie. So first of all, no one ran my credit. No one knows if I had good credit or not. And she had no job for some time. I worked 2 jobs while my son was sick. 2 jobs. So, finding facts and conclusions of law. The court finds Bobby did not commit marital waste by paying the balance of his pre-marriage student loans of $8,374.03 with funds Lindsay provided, and subsequently, Lindsay is not entitled to reimbursement. The court further finds the parties purchased the home in January 2018 and began the process of looking for the home sometime in November 2017. Both parties were aware the student loans would need to be paid off in order for Bobby to qualify for the mortgage and necessary to purchase the home. They can tell you nothing that ever told me he had student loan debt. Nothing. And that I was going to pay it. Nothing. Both parties were achieving their goal by attaining community property residence. I didn't even want a house. Lindsay had knowledge that Bobby would need to pay off student loans and agreed to provide the funds necessary. They stole the student loan money out of the deposit. The court further finds that the parties' realtor, Linda Knott, emailed a closing disclosure to the parties. On the closing disclosure, admitted as evidence, the payoffs for the student loans were listed. Mind you, she sent me that closing disclosure after I canceled. And she closed in 2 days, not 3, for me to review the closing disclosure. The court further finds that Lindsay did not meet her burden of proof in the claim of marital waste under Putterman and Putterman. Lindsay presented no evidence of compelling reasons for the court to find waste such as Bobby hiding, wasting, or misappropriating or otherwise using funds Lindsay contributed for his own personal interests. So I guess paying off $20,000 of his debt in his student loans wasn't marital waste. It was the lender who required Bobby to pay the loans to be paid in order to qualify for the purchase of the community property asset. No, they could have simply said he doesn't qualify. Almost all marriages involve some disappropriation of contribution or consumption of community property. Such retrospective considerations are not and should not be relevant to community property allocation and do not present compelling reasons for unequal distribution, hiding, wasting, misappropriation of community assets. He hid the fact that I wasn't on the title. He wasted over $25,000 paying off his own debt. So, Rena Hughes, what's wrong with you? The court further finds that Lindsay's testimony is not credible when she said that she had no knowledge that Bobby's student loans would need to be paid off in order to qualify for the mortgage to purchase the marital home. The court further finds over a month before closing, Bobby was aware that he would have to pay off the student loans. Bobby and Lindsay discussed this very issue. No, we didn't. He never told me. They were both aware that the lender required Bobby's debts, including student loans, credit cards, car loans, to be paid off prior to closing or at closing. Well, then why didn't you guys request gift letters for it so I would know? When Bobby ended up paying off certain debts prior to closing, it caused the lender to require explanation into why the conducting transactions ahead of time, rather than at closing. Both parties were frustrated with the lender's requirements throughout the qualification process because they did not understand why the lender was requiring explanations of numerous financial transactions. The court further finds that the lender required Bobby to pay off student loans in order to close on the purchase of the marital home. When the loan closed, the parties agreed Lindsay would be repaid a certain amount in exchange for contributing her separate property funds towards the purchase, which will be described detailed herein. Bullshit. The court finds Lindsay did not intend to give her sole and separate property to the community when she executed the gift letters of Bobby qualifying for the mortgage to purchase the home of residence. That's probably the only true thing she wrote in here. The court further finds that both parties intended and agreed that Lindsay would provide the funds for the down payment, escrow deposit, and to pay off certain premarital debts owed by Bobby. Lindsay's sole separate property funds were exclusively used for the down payment, escrow deposit, Bobby's auto loan payoff, and student loan payoff. All funds were traceable to Lindsay's separate property. The court further finds that during the closing process on the purchase of the marital home, that Lindsay signed multiple gift letters. However, the court finds that sole purpose for the gift letter was to help Bobby qualify for the mortgage to purchase the marital residence that would serve as a community property. While Lindsay did add Bobby to her bank accounts as a joint holder in 2017, she then closed those accounts and opened new accounts in only her name. Because after they stole my money, I closed all my accounts and opened new ones. It was from this account that the funds were associated with closing were wired. Lindsay evidenced her intent that the funds would not be gifted multiple times. So I tried to protect myself several times. And she also admits right here, it came out of my personal account because Bobby was never, ever on my business account. First, Lindsay's evidenced her intent not to gift the funds when she attempted to cancel the purchase, even though she was not a party to the contract. Second, Lindsay required Bobby to sign a letter of agreement acknowledging the funds were not a gift before she would wire the funds to complete the purchase. No, I told him to acknowledge they were not a gift before I signed a duplicate gift letter, which you guys saw in the evidence. The court further finds that Lindsay drafted a letter of agreement on the date of closing, January 17, 2018, stating, that Lindsay Ante and Bobby Ante are in agreement that the following regards to: if a divorce takes place, $75,000 returned to Lindsay Ante and the remaining equity will be spent 50-50. I am aware of the community property law. Upon divorce will be sold and $75,000 will be returned to Lindsay. The court further finds Lindsay sent the agreement to Bobby while he waited at the title company to finalize the purchase transaction. And the parties had not discussed this agreement prior to sending the same to Bobby that day. Lindsay's handwritten signature appears on this agreement. So she admits, I wasn't with him. I had to email him this agreement. The court further finds that there was a second draft of the letter. There wasn't. His lawyer made all this up. Lindsay claims she never saw the second version except for through discovery and litigation. This second version does not contain Lindsay's signature. The second version of the letter contains a different format, but operatives, the terms only differ slightly. The second version states in the pertinent part, Lindsay Ante and Bobby Ante are in agreement that in the regards, if the divorce takes place, $75,000 returned to Lindsay Ante and the remaining will be split 50-50. So his lawyer takes out the whole part about him being aware of the community property laws. And you can see it was uploaded 2 years ago, just as it was written. The court further finds Lindsay's testimony that she was unaware of the second letter of agreement and hadn't seen it prior to discovery not credible. Lindsay sent a text to Bobby asking if he was going to sign the updated agreement. It is clear that Lindsay knew there were two agreements, but it was unclear which was the first and which was the second. Even so, Lindsay had to acknowledge there was two agreements. Not true. So I sent Bobby an agreement. He didn't sign it. I then said, hey, I'm updating it. I'm adding that there's community property laws. So he signed both. He admitted in court, signing both. But there was never two drafts. There was one completed letter of agreement. That's it. His lawyers made up a whole nother one. The court further finds that the operative terms in common that in the event of divorce, Lindsay would receive $75,000 and the remaining equity would be divided 50-50. The only operative term not in common that the home would be sold. In her complaint, Lindsay requested the marital resident be awarded solely to her and that Bobby should repay the loan of $75,000 to her. So, another like term in these agreements that they fabricated, the second one, was that he would be responsible for all the legal fees. So how the hell did I get stuck with them all? The court further finds that concerning the common terms, Lindsay would receive $75,000 from the equity of the home and the remaining equity would be divided 50-50. There was a meeting of the minds and the contract was made. The court further finds Lindsay communicated to Bobby that she would not wire the funds to close on the sale if he did not sign the letter agreement. As a result, court finds Lindsay is entitled to $75,000 from the equity of the marital residence, and the parties will divide the remaining equity 50-50. Now, the problem with this is you don't commit a crime and forge my name and go to a closing and then get half of my equity for doing it. The court further finds Lindsay's testimony that she did not know she was wiring the funds to close on the sale not credible. First, Lindsay went to the bank by herself, wired the funds, utilizing instructions provided by the escrow company. We saw in the evidence, Bobby gave me the wire instructions. I never talked to the escrow company. By filling out a wire transfer form at the bank, her actions completed the process necessary for the purchase of the marital home. Second, Lindsay sent a text message to Bobby that she was sending the money, that she would sign a quitclaim deed for the home and go to heaven and be with her son. That was her saying, I authorized it. Let me read that again for you. Lindsay sent a text message to Bobby that said she was sending the money, that she would sign a quitclaim deed for the home and go to heaven and be with her son. This message was a cry for him to pay attention. And I said, you want the fucking house? Then fucking take it. I'll just go die. But that was Rena Hughes saying, it's great. She said he can buy the house. But it still wouldn't let them forge my name to a quitclaim deed. Yet at trial, Lindsay claimed she did not wire the funds. Lindsay asked for a divorce on the same day, drafted and signed the letter agreement, and wired the funds to the title company to close the transaction. Lindsay then claimed she was shocked a few days later when she saw the funds were transferred from her account. It's difficult to find Lindsay's testimony credible, and this court does not. Well, you cannot tell somebody that they're going to be on a title of a home and then not put them on it. You cannot tell somebody to take instructions to the bank, which is what Bobby told me to do, and then tell me I'm going to get to look over the paperwork before there's any closing and then just close. So, yes, I went to the bank with the belief that I was going to be able to look over documents. When I left the bank, my money was still there. Had no reason to believe. Nothing happened until the next day when the money was gone. And I showed you here in all the evidence, I told him I wanted a divorce the same day. So let's go on with Rena Hughes' fake ruling. The court finds Lindsay did not meet her burden of proof that the funds she gave to Bobby in the amount of $26,100 to place into his Goldman Sachs savings account constituted community waste, are conversions of her sole and separate property. The court further finds that prior to the parties' marriage, so we weren't married, Lindsay gave Bobby $26,000 in cash to deposit into the savings account. This was an account Bobby held before the marriage and had a balance approximately of his own money of $13,000 prior to putting my money in the account. The court further finds Bobby's wages were regularly deposited into the same account. There was a commingling of the parties pre-marriage and the sole and separate funds once they were combined into the Bobby's Goldman Sachs account. Now, first of all, Bobby didn't deposit his wages into this account. He deposited a small portion of his wages into that account. There is no card for that account. So the only person who had access to this Goldman Sachs account was Bobby. So even in the commingling of the parties, he was simply supposed to put the money in the savings account. I never authorized him to spend anything. I then provided Rena Hughes with evidence of my own bank statements, my personal bank statements that Bobby had nothing to do with, that I was using my own money. So there was no commingling of anything. The court further finds Lindsay did not meet the burden of proof when she gave Bobby the funds to deposit into his existing bank account. She did not intend to gift the money to the community of her sole and separate funds. So I'll just keep going. The court further finds Lindsay did not meet the burden of proof that Bobby misappropriated her sole and separate funds for his own use. The managing spouse must keep the community and sole and separate property segregated. If the community and separate property becomes intermingled, it is managing spouse's burden to prove the separate nature of the property so claimed. And she puts some lucci. The court further finds Lindsay was the managing spouse of her own separate funds and provided no evidence that she intended to keep them separate, did not intend to gift them to the community, or that Bobby misappropriated them. Yes, I did. You guys saw that and all that I provided. The court further finds that the parties' testimonies and exhibits admitted into evidence showed that Bobby would transfer funds as needed from his Goldman Sachs account into his Bank of America account in order to pay community expenses. The court further finds when Lindsay gave the money to Bobby, Bobby would place the funds into his Bank of America account, then transfer the funds into his online savings account with Goldman Sachs. So she just said that we were both using the account. Now she's saying that he only had access to it and that there was no card for it. It was just a savings account. Separate property placed into joint tenancy is presumed to be a gift of half interest to the other party, unless the presumption is overcome by clear and convincing evidence, such as forgery or fraud. The opinion of either spouse is of no weight. The party who wishes to overcome the presumption must do by presenting substantial evidence of conduct, expressions, intent, or the time of taking during the holding of the property. I did that. The court further finds Lindsay failed to meet her burden of proof, and giving the funds to Bobby deposited in his account did not constitute a gift. Lindsay agreed to commingle her funds with Bobby's funds already in the account and use the combined funds for the use and benefit. It was the party's intent to commingle the funds into a joint savings to be maintained as a community asset. Don't know where she got that from, because Bobby said at court it was my savings and that it was my own money. It was there for interest, and the only reason he used it was because the mortgage company told him to. The court further finds that the parties regularly used Bobby's American Express credit card for multiple purchases and entertainment. Bobby would then pay off his credit card from the commingled funds. In arrest 123170, it's clear that either spouse may, without the consent of the other spouse, convey, charge, encumber, and otherwise dispose of his or her separate property. Bobby did not commit waste or misappropriate funds for his own benefit, as charges in the card were community in nature. I never had access to Bobby's American Express. I never used Bobby's American Express. So I don't know where she's getting this from. Fraud in the purchase of the marital home. The court further finds Lindsay did not meet her burden of proof by clear and convincing evidence that Bobby committed fraud against Lindsay by having the marital home placed solely into his name at the time of purchase. In order to demonstrate fraud, Lindsay must be required to provide clear and convincing evidence. An expert, clear and convincing. Bobby admitting I wasn't there, clear and convincing. The realtor saying we'll both be on title, clear and convincing. Bobby made a false representation or misrepresentations as to the past or existing facts. Prove that. That Bobby had knowledge or belief that such representation was false, or that he lacked sufficient basis information to make representation. That Bobby intended to induce Lindsay to act in reliance upon the representation. That Lindsay justifiably relied upon the representation. That Lindsay reliance upon Bobby's representations caused the damages. I've proved all that in all of this that I filed 2 years ago. The court further finds Lindsay failed to meet the burden of proof of fraud. Bobby did not commit fraud upon Lindsay when he purchased the marital home alone in his name. The grant bargain deed of sale Lindsay signed at the closing transaction required by the lender in order to vest title in Bobby's name. As Bobby was the only one appearing on the mortgage, Lindsay claims she did not sign the deed, but her testimony is not credible. The grant bargain deed of sale signed by Lindsay, stamped by the notary, that was also the escrow agent that notarized her own document. Lindsay has since sued the notary, Nikki Bott, and realtor Linda Na, involved in the transaction. Why the fuck would the divorce judge need to know any of that, besides ex parte communications? The court further finds it was the intent of the parties that the title would be vested in both Bobby and Lindsay's name after the transaction closed. Where'd she make that up? And why would you wait till after the transaction closes? Makes no sense. Because the marital home would be a community asset. The court further finds Bobby never intended to exclude Lindsay from ownership of the home and that he always considered it their home. The court finds his testimony to be credible. But you saw him kick me out of the home. You saw they forged my name. The escrow agent notarized her own document. And then he conspired with them for 3 years. So that's who's credible? The court further finds the title was never changed to list Lindsay's name due to serious marital discord that existed from the time the transaction closed. In large part due to Lindsay's distrust over how the transaction was conducted, although there was nothing illicit or fraudulent occurred in the transaction. Wait, she notarized her own document, Rena Hughes, you dumbass. The term of the transaction were not dictated by Bobby, but the lender and the title company. However, Lindsay continues to blame Bobby and the realtor. I never met the lender. I never went to the title company until the day they screwed me. So all of this that she's writing, completely fabricated. She has no evidence. She's just writing. And she's a family court judge. So why you keep talking about a civil matter? It's not your area. The court further finds that Bobby made no marital misrepresentations to Lindsay to obtain her signature on the deed. The lender required the deed in order to keep title to the property clear and to avoid any community property or spousal claims of interest. However, between both parties, they agreed it was community property. The single fact that Bobby did not execute a deed to convey a written community property interest to Lindsay was not fraud. Bobby also acknowledges that Lindsay owned an equal interest in the home. But now they've taken my entire home and they're making me pay $65,000 in legal fees. The court further finds both parties offered testimony concerning stemming from the joint tax return they filed in 2017. Lindsay provided evidence that $1,300 were garnished from the parties' tax return due to Bobby's past due child support. Bobby provided evidence that Lindsay underreported her income in 2017, which resulted in an IRS tax obligation of $10,170 levied against the parties jointly in 2019. Another lie. The court further finds that Lindsay did not agree to pay Bobby's premarital child support obligation from the community funds they were received through their tax refund. As a result, Bobby owes Lindsay reimbursement of 100% of the funds taken. So she gave me back the $1,300 for the child support. The court finds that underreported income for 2017, as a result, the IRS debt, the amount of $10,170 shall belong to Lindsay as her sole and separate obligation, reimburse Bobby. Bobby didn't pay no $10,000. I don't even owe $10,000. I've already proven that. So they just began making up stuff in this return. So now that I protected myself with the $75,000, they got to chip away at that. So now she's just making up shit. Reimbursements. The court at the case management conference on October 19, 2018, this court ordered Lindsay to reimburse Bobby for all utilities paid while she had exclusive possession of the marital home. At the trial, parties provided evidence that Lindsay had had been the sole occupant of the marital home since Bobby moved out in June 2018. From July 2018 on, Lindsay was the only party living in the home. Bobby requested reimbursement for all expenses covered for the marital home while Lindsay was there exclusively. Additionally, Bobby requested reimbursements from Lindsay for July 2018 on charge on his Bank of America credit card to Aiden's Army. The court further finds that Lindsay shall be solely responsible for the expenses of the marital residence while she lived there exclusively. Additionally, Lindsay shall reimburse Bobby all mortgage payments, HOA fees, utilities he paid after October 2018. He didn't pay anything after October 2018. Pursuant to the court order at this time, Bobby shall be reimbursed from Lindsay's share of the equity proceeds of the marital residence after she receives the $75,000. So now he forged my name, he committed fraud, and now she wants me to give him some more money. The court further finds that the charge Lindsay made on Bobby's card to Aiden's Army was not spent for the community, but is a contribution to her separate property foundation for which she should reimburse Bobby. Bobby shall reimburse from Lindsay's share of the equity proceeds, a sale of the marital residence after she receives her initial $75,000. The court shall retain jurisdiction to determine the distribution of the sale proceeds in accordance with the order. Damages to the marital home and Lindsay's personal property. Again, remember, we went over all this. At trial, Lindsay claimed Bobby caused damage to her personal property when he removed items from her storage and the marital residence when he moved out. The court finds that Lindsay provided insufficient evidence at trial of these damages, so the claim must be denied for her failure to meet burden of proof. Health insurance. At trial, Lindsay claimed that she was owed reimbursements for medical expenses incurred as a result of Bobby removing her from his health insurance. This court finds Lindsay did not provide sufficient evidence at trial of these expenses, so the claim was denied, failure to meet burden of proof. Well, you guys just saw. It was about 7 bills at the end that I provided 2 years ago. At trial, Lindsay sought reimbursement from Bobby for a fee associated with breaking her lease for an apartment she rented prior to the marriage. The court finds this is a debt Lindsay's sole and separate property, and she shall be responsible herself. So he moved into my house after my son died. He lived there for free for 3 months, and then he gave the notice to buy this house, and then I couldn't take the notice back. So it's very confusing to me as why everything Bobby did, I pay, but everything Bobby did, I still pay. So he doesn't pay anything. Attorney fees and costs. At trial, both parties requested attorney fees and costs from under various claims at law. The court finds each party may file a motion for attorney fees within 30 days in which she granted his attorney $19,000. It is therefore ordered that the parties granted full and final divorce and return to the status of single and unmarried persons, that neither party is entitled to receive or will receive any alimony from the other party, that the residence be listed for sale within 10 days, and that I can pick 3 realtors, and then Bobby can pick which one of those 3 realtors will sell the house, and then they will sell the house. And once the property is sold, Lindsay should have exclusive possession of the marital residence and should be solely responsible for the mortgage, HOA, utilities. So I'm forced to stay there. I'm responsible for all the bills while I wait, and I have been for 3 years. But once it's sold, Bobby gets everything. It's further ordered and adjudicated that from the proceeds of the sale of the marital home, Lindsay shall receive the net sales proceeds contracted amount of $75,000. Remaining equity will be dispersed from escrow and decided equally among the parties. So you can commit fraud, you can forge somebody's name and put a house in your name illegally, and then at the end, you get to be rewarded again. So not only did he steal the $26,000 pay off his debt, he stole the $8,000 pay off his student loans. Now he wants to steal half of the equity that I've built because I've been forced to live in the home. And then she says, to reimburse him mortgage payments from July to October. He didn't make any mortgage payments from July to October. Mind you, he left my house with all my money. So even the payments he did make when we were living in the house, he was making with my money. He didn't make any payments. And then they say reimburse him for Republic services. You guys saw in the evidence there, he wasn't even paying Republic services. He wasn't paying the HOA. And when I used his card for the foundation, I did. But I asked him. He gave me the card and the number, and I used it because he told me I could. So In sum, Bobby shall receive a total reimbursement of $6,113.36. And these funds shall come out of the equity that goes to Lindsay. It's further ordered that Bobby shall reimburse Lindsay a total of $1,300 for the funds garnished in the tax returns. And Bobby should pay Lindsay from his share of the marital home proceeds. Well, when you commit fraud, you don't have a share. And it's further ordered that Lindsay should be solely responsible for the IRS debt associated with the parties' joint filing tax return 2017, totaling $10,170, a completely fake, fabricated bill. It is further ordered that Lindsay is solely responsible for the costs associated with breaking the lease agreement entered into before the marriage and hold Bobby harmless therefore. Even though the $26,000 was given to him before the marriage, but he gets to keep that. But I have to pay the lease break fee because I got it before the marriage, but he lived in it and he broke the lease. So each party shall retain his or her own personal property acquired prior to the marriage. Well, all that money, it was my own personal property and it was required prior to the marriage. And A and B list should be drafted by Bobby within 10 days and the divorce decree should go through and they have 10 days to choose a realtor. The court will remain in jurisdiction over all matters regarding the property to settle disputes. It's a civil matter. It's not a family court matter when it comes to fraud on a piece of property. It is also ordered that each party can file for attorney fees, that Lindsay shall have her name restored, and that, that each party shall execute all legal documents, certificates, titles, bill of sale, deeds, or any other evidence transfer necessary to effectuate this degree within 5 days. So now that I've caught them all, they want to hurry up and rush everything. So now I've already showed you this complete ruling, fabricated. You saw the damage to my home. You saw the damage to my property. You saw that Bobby thought this was a big joke, the conspiracy with his lawyers. But this is how our legal system works. They can simply do whatever they want. They can say whatever they want and lie about whatever they want. So, this is how easy it is for a judge, lawyers, and people to take advantage of completely innocent people and try to deprive you of everything. So, I will not be leaving my home. I will not. I know I'm entitled to lease pendants. And when people commit fraud in a mortgage transaction, the person who is affected is entitled to the title of the home. And the people responsible for committing the fraud are required for paying for that home. So therefore, it makes a lot of sense why everybody wants to convince you guys that I'm just so disgruntled and I just want to get a refund on my life. When really the fact of the matter is they committed fraud. And they don't want to be responsible for paying off this house, for paying off my damages, for returning the money that was stolen from me. They don't want to be responsible for any of that. So Rena Hughes did her very best to try to manipulate this case, to try to put in fake orders. And for 2 years, knowing everything that transpired, let me be abused, attacked, lied about, and now the attack is on my foundation. And I'm sure that's because I made such a point to prove how honest I was and how this had nothing to do with my foundation. So what better thing to attack than that? Well, Rena Hughes, I am happy you lost your seat. And I am happy you will never, ever hurt another mother like I did. And I will continue to file into these cases until I get my annulment and I get my restitution and damages owed to me. I want Bobby Ante arrested. I want Linda Na arrested, and I want Nikki Bott arrested. And I'm not going to continue to let myself be slandered, to let my work be slandered, when it is this clear and concise. And you guys have let this continue for years. Not one person caring that I lost my son, that I have a million things on my plate, and all I want to do is help kids. That's all I want to do. I want to help kids, and I've done this honestly, purely, and the one thing I did wrong was marry this guy. And he has brought pure hell into my life with this realtor. And it's disgusting. You cannot buy a house as a married man without your wife there. It's illegal. You can't hold a closing without both parties present. We see several times I wasn't there. So they stole my money. They stole to get the house. They forced me to pay for the house. They forced me to remain in a marriage with a man who was abusing me, lying to me, and stealing from me. And now that I caught them all, they want to rush me out of this house, sell it, and throw me and my mom in the street for me doing nothing to nobody. So I'm going to do a couple more videos. And after that, I'm giving this to God, because I have spent 3 years doing this. I've spent the last 7 months litigating my own cases. This is what my life has turned into. All these cases, and I'm a victim of a crime. So for you to understand kind of what I'm